So we have a major shift and update in a critical case dealing with a magazine ban restriction, essentially a ban on magazines that hold more than 10 rounds. And this is one of the biggest developments that we've seen by far, and this is in a critical case that is likely eventually going to make its way to the Supreme Court. Recently, the full court officially stepped in and agreed to rehear this specific case en banc, but now we have another development that's layered on top of that. The court was recently asked to stay this en banc rehearing in light of the Supreme Court recently granting review to two critical AR-15 ban cases, and we've talked about those before. Those are the Viramontes case and then also the Grant case. The court was asked to slow this case down temporarily and wait for the Supreme Court to issue their new ruling in those two current and pending AR-15 cases. And the court here, hearing DC's ban on magazines, actually agreed to stay this case and wait to see what the Supreme Court does with the AR-15 ban cases. So let's break down what this means and what happens now going forward. Now, before we jump into this video, if you like this type of content and you want to ensure that you get it going forward, make sure you subscribe to the channel and also turn on all notifications to ensure you never miss these videos once I release them. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always trying to expand upon their benefits to give you as much as possible as a member. And right now, if you decide to sign up using my link down below and you use my exclusive code ARMEDSCHOLAR, you can get $50 off of your individual sign-up fee or $25 off of the family fee. Now, as I mentioned in the intro, we have another important update in the Benson DC magazine ban case. And first, let's kind of quickly recap what happened in this Benson case, because this is critical to understand where things currently stand. The DC Court of Appeals originally ruled that the district's magazine ban violates the Second Amendment. Not only did the court strike down the ban outright, it also vacated multiple related convictions that were tied to that ban. So those included things like the unlawful possession of an unregistered firearm, the unlawful possession of ammunition, and carrying a firearm without a license. The court there said that those convictions were infected by the unconstitutional magazine ban in DC, and so that was a sweeping ruling with major consequences and really benefit Mr. Benson. And ever since that ruling came down, DC has been trying to contain that ruling. Now, after losing, DC filed a petition for a rehearing en banc and tried to fast-track review and also limit the impact of that ruling. However, that expedited review was initially denied, but then the United States actually stepped in and argued that the court went too far in its remedy and that the full court needed to review the case, and eventually that effort succeeded. The DC Court of Appeals officially granted a rehearing en banc in this case, and once that happened, the original March 5th opinion was actually vacated. And that means that the ruling striking down the magazine ban in DC is no longer binding, it has no precedential effect, and the entire case is now being reconsidered by the full court. So that strong pro-2A actual ruling that we got out of DC that we've been discussing previously is effectively now on pause. Now, in this case, the first briefs were originally due on July 20th, and they were supposed to kind of play off the recent Supreme Court 2A rulings in cases like Wolford and Hamani that we got at the end of the Supreme Court's last term. However, on July 8th, Benson's counsel filed an unopposed motion to stay the en banc briefing. So essentially, a stay is a formal procedure requesting and essentially asking the court to temporarily pause all deadlines and proceedings in the case. The justification for this specific pause is this monumental announcement that we got from the Supreme Court at the end of their term as well, which was that they are now going to review, and they've granted cert to two critical 2A cases dealing with AR-15 bans, and that is the Viramontes versus Cook County case, and then also the Grant versus Higgins case. Both of these Supreme Court cases deal with direct constitutional challenges to state and local bans on AR-15s and other semi-automatic rifles that accept magazines capable of holding more than 10 rounds. Benson's legal team argues that the Viramontes and Grant case present the exact same core legal issues that the full DC Court of Appeals will be trying to resolve in this Benson case. They argue that the Supreme Court is preparing to decide what arms are covered by the plain text of the Second Amendment, what it truly means for an instrument to be in common use, and the actual scope of the nation's historical tradition regarding claimed dangerous and unusual weapons. Now, currently, the petitioner's briefs that are going in front of the Supreme Court in the Viramontes and Grant versus Higgins case are due on August 14th, with oral arguments that are going to likely happen later this year or early next year. And then a final Supreme Court decision will likely drop at the very latest by the end of their term, which is in the summer of 2027. Benson's counsel argued to the court that because the Supreme Court's impending ruling will likely resolve the exact issues at play here in this Benson case, it would be highly inefficient and unhelpful to force the parties to brief this en banc case right now without knowing what the Supreme Court is actually going to do on these issues. And here really is the key procedural detail. The federal government and the District of Columbia have both been consulted and they do not oppose this stay. Both sides realize that if briefing moved forward immediately, they would just end up rewriting or supplementing their arguments the second that the Supreme Court drops those new rulings in the Vermontes and Grant case. So where does this currently leave us? Well, the full DC Court of Appeals will still eventually rehear the case en banc. They will still reconsider whether magazine bans are constitutional and whether the prior remedy vacating the related convictions was proper. But procedurally, all of this analysis is now hitting the brakes, and the court can essentially just sit and wait and watch for the Supreme Court to tackle the Vermontes and Grant case and address all of these types of issues in their AR-15 ban cases. So right now, the fate of the DC magazine ban is really kind of tied to the ultimate Second Amendment cases and the showdown that we're looking forward to at the Supreme Court level dealing with AR-15 bans. And if the AR-15 cases go our way, which I do believe that the Supreme Court is going to rule in our favor, that means essentially that we have a magazine ban challenge that is teed up at a very high level of a court, essentially ready to play off what the Supreme Court says in the Vermontes and Grant case. And honestly, this delay may actually make sense strategically. If briefing moved forward right now immediately, both sides would likely have to supplement or rewrite major portions of their arguments after the Supreme Court issues those rulings in the AR-15 ban cases. So the stay avoids that problem and lets us potentially get a quick follow-up win on magazine bans after the Supreme Court issues those rulings. But also importantly, it ties the future of the Benson magazine ban case directly to what the Supreme Court is going to do this term. So the Benson case just took another major turn. Not only was the original decision wiped out, but now the full court has officially slowed the case down to wait and see what the Supreme Court does. And that means that the future of this magazine ban challenge may ultimately depend on what the Supreme Court does their next term. So that's what's currently going on in this critical Benson magazine ban case that we've been following. It is now on hold. They're going to wait to see what the Supreme Court does with the AR-15 ban cases. And like I said, my anticipation and my expectation really is that the Supreme Court will rule in our favor when it comes to these AR-15 ban cases. And that's going to have a trickle-down effect on these other types of issues like state magazine bans. But we're going to have to wait to see. And now also the court in the Benson case is also going to play that wait and see strategy. So that's what's currently going on. As we get more information, as it develops more, I will let you guys know. If you like this type of content and you want to ensure that you get it going forward, make sure you like, comment, subscribe, and also turn on all notifications to ensure you never miss these updates when I release them. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.